Okay, so we should start right now.
Yes,
And
yes, sir. Yes.
if anyone will join, it's okay. So first of all, we have to know take we are going to take you on the subject Bharati Sakshi Adhiniyam. The Bharati Sakshi Adhiniyam has been enacted in the year of 2023, and it is replacing the Indian Evidence Act 1872. The President has consented to the Bharati Sakshi Adhiniyam on 25th December 2023, and finally the Government of India has announced from 1st July 2024 all the three criminal laws will be applicable, and they have been applied from 1st July 2024. This is the commencement date of the Bharati Sakshi Adhiniyam. Now, before moving towards the what changes have been done, what relevant provisions have been made in the Bharati Sakshi Adhiniyam. So, what was the objective to replace all these three criminal laws? So, basically, there was an objective that there must be an Indianization of the laws, because India has the laws which has been made from the British India and the colonial India's laws, which contained some provisions like the sedition, and many more provisions. Therefore, we needed and much needed laws which are required by the India. Now it has been finally been made. Bharatiya Sakshi Adhiniyam 2023, Bharatiya Nagrik Suraksha Sanhita 2023, and Bharatiya Nyaya Sanhita. So we have discussed rest of the tools, that is BNSS and BNS. So today we are going to discuss the Bharatiya Sakshi Adhiniyam 2023. As I told you, the objective of the laws was the Indianization, because we need such a law which must be made by the representative of the democratic India, representative of the independent India, because all these laws which were being replaced by the BNS and the Bharati Sakshi Adhiniyam, these were the intention of the Britishers. Therefore, India now has their three criminal laws. Now, Bharati Sakshi Adhiniyam. The Bharati Sakshi Adhiniyam, we are going to state the salient feature of Bharati Sakshi Adhiniyam 2023. We will cover the brief introduction regarding the Bharati Sakshi Adhiniyam, and later on comparative chart between the Indian Evidence Act 1872 and the Bharatiya Sakshi Adhiniyam 2023. And fourth one is action required to implement the Bharatiya Sakshi Adhiniyam effectively in the state of Haryana. There are some training required for the implementation of the Bharatiya Sakshya Adhiniyam, and lastly, we will discuss the latest judgment on the admissibility of the electronic evidence, because the one major change being made under Section 61 of Bharatiya Sakshya Adhiniyam is the admissibility relating to the electronic evidence. Electronic evidence, digital records, and electronic evidence. So, what are the salient features of this Bharatiya Sakshya Adhiniyam 2023? So, first objective of this Bharatiya Sakshya Adhiniyam is to consolidate and to provide for the general rules and the principle of evidence for fair trial. And this act has repealed the Indian Evidence Act 1872. Hereinafter, we can call the Bharatiya Sakshya Adhiniyam, which is primarily focusing on the procedural aspect of the laws, governing the rights by which they may be enforced before the court of law. And there are some fundamental changes have been made under the Bharatiya Sakshya Adhiniyam, which are the examination of the witnesses. Only before the Bharatiya Sakshya Adhiniyam, the examination of the witnesses was only being done by presenting before the court or by issuing a commission. But now, audio, video, electronic means, or by digital evidence, there may be the examination of the witnesses or the parties. But there must be the first and foremost principle of the rule of natural justice, audio non partem. This is the basic and natural laws we dealt with. No one can be unheard. No one can be condemned. Okay. So second key point is brief introduction regarding the Bharatiya Sakshya Adhiniyam. The Indian Evidence Act contained 3 parts, 11 chapters, and 167 sections. But our Bharatiya Sakshya Adhiniyam contains in 4 parts, 12 chapters, and a schedule, and 170 sections. So primarily, part 1 contains preliminary clause. Preliminary clause, where you will study about the definition of the act, definition clause. Here, under the Indian Evidence Act, the definition clause was given under the interpretation clause, under the interpretation. But now it is being given in the section 21A, 21B, 21C, D, E, F, as so on. And what will be the remaining 3 parts? The second part will be the relevancy of the fact. Relevancy of the fact, that is chapter 2nd. And third part will contain on the proof of the matter, that relates to section chapter 3 to 6, that is section from 51 to 103, and last chapter, production and effect of the evidence, that relates to the chapter 7 to 12, and sections 104 to 170. So we are continuing the first part relating to the definition clause. Here, under the Indian Evidence Act, the word document only does not include the audio, video, electronic means. The document does not contain such provision. But under the Bharatiya Sakshya Adhiniyam, it contains the provisions, and it contains the document which may be taken by audio, video, electronic, and digital records, also known as the document under section 2E of the Bharatiya Sakshya Adhiniyam. So are you getting the point what I'm trying to state? So is it clear to you till this point? So I have to proceed further or to explain more?
Yes, sir, it is clear.
So, okay, thank you. Now, what section 2 is state? The act recognizing all documents, including the electronic or the digital records produced for the inspection of the court as a document of evidence. Is it clear? Now, move further. The changes in the part seconds are in this part, the clause relating to the relevancy of the facts. The different aspect related to the facts, such as the closely connected facts, surrounding facts, becoming more relevant in an attempt to prove facts in issue or relevant fact under section 7. And before moving further, I want to state you, if you have the bare act of the Indian Evidence Act or the Bharati Sakshya Adhiniyam, there is one major change under section 6 of Indian Evidence Act and section 4 of Bharati Sakshya Adhiniyam. So do you have bare act with you? So anyone? Anupriya?
Yes, sir.
So see the section 4. What section 4 states? Under the Bharati Sakshya Adhiniyam, and section 4 states, I'm reading out the section. I'm I'm here to clear you the doubt. What is the relevancy between section 6 and section 4? Section 6 of Indian Evidence Act and section 4 of the Bharati Sakshya Adhiniyam, and what changes have been made? Relevancy of the facts forming the part of same transaction. This is dealt with res gestae. Rule of res gestae is a principle from the English laws being incorporated under the Indian Evidence Act 1872, which has been again incorporated under section 4. But under section 6, there was only one thing, but there are two things. What these are two things? So I'm reading out facts which, though not in issue, are so connected with a fact in issue or relevant fact. So if you will see the section 6 of Indian Evidence Act, you will find only the fact in issue. Section 6, I have the bare act of the Indian Evidence Act also, so I'm reading section 6, and section 6 states facts which, though not in issue, are so connected with fact in issue as to form. It means it does not, it did not contain the provision relevant fact of the same transaction. It means now the relevant fact are also be the part of same transaction. Be the part of same transaction. If you are really being gone through to the section 6 of the Indian Evidence Act, you may understand the difference between the fact in issue and the relevant fact. So are you clear with this point? Because this is the main change under section 4 of the Bharati Sakshya Adhiniyam, because this act relating to this act states that part of the same transaction relating to the fact in issue or relevant fact. For example, A, B, C are agrees to the wage war against the government of India. Waging war against the government of India. A resides in Calcutta, B in Delhi, and C in Madras. So they agrees to the wage war against the government of India, and A collected a money from Calcutta, B collected the arms and ammunition in Delhi, and C, who is residing in the Madras, Chennai, he has also agreed to receive some funds and arms and ammunition in Chennai. Whether these are the part of same transaction under the provision of section 6 of Indian Evidence Act or section 4 of the Bharatiya Sakshya Adhiniyam. Tell me. Do you think this is the part of the same transaction? Yes, it is the part of the same transaction because they are directly connected to each other. It will be the part of the same transaction. For example, if a lady come out from the house, she had been ravished and raped by some person. She told her mother after 1 hour of committing a rape, Mom, X and Y or only X has committed a rape. So whether the statement given by a lady to her mother after a span of 1 hour is a part of the same transaction, whether the statement of the mother will be relevant, will be the part of the same transaction. If we talks about the Indian Evidence Act 1872, it was not relevant. R versus Christie. There was a case, the name was R versus Christie, but now under the Bharatiya Sakshya Adhiniyam section 4 states, it may be the relevant fact. The statement given by the victim to her mother may form the part of the same transactions. If you are clear with this, so please let me know, and then I will proceed further.
Sir, I had a doubt.
Yes.
Sir, in section 4, what does the line "the court may presume a fact" mean?
What?
In section 4 of Indian Evidence Act?
No, no, no. May presume we will state, but here first this, then I will move on your topic. Are you clear
Okay.
with section 4 of the Bharatiya Sakshya Adhiniyam?
Yes.
So yes, section 4 of the Indian Evidence Act state may presume. May presume means the court may presume certain fact as proved until and unless they have been disproved. Relevancy of certain facts may be proved. The court may presume the relevancy of the fact of the certain facts. It means it is the discretion of the court. May presume means it is the discretion of the court to presume any fact as proved. And shall presume means here the court is bound to presume such fact is proved. And in conclusive proof, there cannot be given any evidence to disprove the fact. Is it clear to you?
Clear, sir.
So next further proceed with some another sections, that is section 7, things said to be done by the conspirator under section 8. That was the conspiracy given under section 10 of the Indian Evidence Act, and the facts not otherwise relevant become relevant under section 9. That could have been the principle of, it could have been the principle of plea of alibi. Plea of alibi means the person is contending that he is somewhere else when the alleged offense was committed. So it was taken under section 9. And section 15 talks about the admission of the facts. And section 22 have been omitted now. And section 2, this is the basic, this is the another provision which I'm emphasizing on it is section 23. Section 23. But firstly, I have to explain section 22. Section 22 states that the confession made under any threat, promise, or inducement is not relevant if it is made to the person in authority. It is clear to you. If any confession has been made by an accused person to a person in authority under Section 24 of the Indian Evidence Act, now under Section 22 of the Indian Evidence Act, is not relevant if it is being caused by threat, promise, and inducement. Here the word, the threat, promise, if the threat, promise, or inducement have been removed, then what will be the relevancy of the confession made by an accused person? It was given under Section 28 of the Indian Evidence Act. It was the lacuna. It was the lacuna given under Section 28 because it is the part of Section 24, but it has been mentioned under Section 28. Now it is being incorporated under the second part and the second subsection of Section 22. After the removal of threat, inducement, or promise, any confession or statement or confession made by the accused person to a person in authority shall be relevant. It shall be relevant and it shall be used against the person. Under Section 183, of the Bharatiya Nagrik Suraksha Sanhita 2023. Is it clear to you? Or the confession made to the police officer? Whether the confession made to the police officer is relevant? Whether the confession made to the person who is in the custody of the police officer is relevant? Whether the person non-confessional statement given by the person under Section 27 of Indian Evidence is relevant. These were the bifurcated sections, Section 25, 26, and 27 under the Indian Evidence Act. But now it has been incorporated under one section, that is Section 23. Any confession made to a police officer is not relevant until and unless immediate presence of the magistrate. Any confession made to a police officer is not relevant. Confession given to the police officer is not relevant at all. If it is made to a police officer in immediate presence of the magistrate, then it is relevant. And when a person is in custody of the police officer, then whether the statement or the confession made to a police officer is relevant or not, it is not relevant. But the custody is a broader term. Let me explain you by giving one example. If in the ancient India, there was a tanga, घोड़ा बुग्गी जिसको कहते थे हिंदी में. There was a tanga, and the police officer who is taken the custody of the accused, he is along with the buggi wala, tanga wala, along with the guys who is riding the tanga, and the accused and the police officer, they were going to produce an accused before the magistrate. But before that, there is a natural call to the police officer. Police officer gone for the natural call, and each and everything has been explained by an accused to the tangawala. That is the rider of the vehicle or the pilot of the vehicle. So whether the statement or the confession made by an accused to a tangawala or to a rider or the pilot is relevant or not? This is the question. Now tell me, is it relevant? Court has stated that it is not relevant because it is in the influence of the person who is riding the such buggy. Now we have to further proceed. If it is clear, we are going to further proceed. Tell me. So I have to further proceed.
Yes, sir, you may
Everyone.
proceed.
Okay. Thank you so much. And now Section 27 also incorporated under Section 23. Any statement or confession made by a person who is in the custody of the police officer is not relevant. But after the statement where some discoveries has been made, something has been discovered in the consequence of the statement, such discovery is relevant. Not the entire statement is relevant, but only some discoveries are relevant. For example, if a person has committed a crime, has committed a murder, A has committed a murder of B by using a sharp weapon, that is sword, and he came to the police station and stated that, sir, I have committed a crime. I have committed a murder. I have committed a murder of B. And the weapon and the sharp weapon which is being used has been put on the specific place. In the consequence of the statement, the police has taken out the weapon which is being used, which has been used by an accused person of committing a murder. Now my question is whether whole statement is relevant or only the discoveries are relevant. So in Palkari Kataya versus Emperor, the Privy Council has held that not the entire statement or confession is relevant made to the police officer. Only in the consequence of the statement, what discoveries has been made is relevant. Should I proceed further? Is that clear to you?
Sir, what about confession in judicial custody?
It is relevant. It is a substantive piece of evidence. The person shall be punished on the basis on that, not the judicial custody to the judicial magistrate. Judicial magistrate. If in the judicial custody, it shall be the extrajudicial confession. Means if it is being made to the inmates of the jail or to the jailer, it shall be the relevant. It will only be relevant. Yes. Only
Can
the
you once
discovery has been, only the discovery is relevant, not the whole statement. Tell me.
so can you once
Clear?
again explain section 27, sir?
Section 27 of Indian Evidence Act states that where an statement made by a person who is in a police custody, whether the statement is confessional or non-confessional, such statement is not relevant. But in the consequence of such a statement, if the discoveries has been made, only that part in which the discoveries has been made is relevant. As I told you the example, as cited the example that a committed a murder of B and he has made a statement before the police officer and the police custody that, sir, I have finished B and the weapon which has been used by me has been put in somewhere in the specific place, and in the consequence of the statement the discoveries has been made. Discovery means the weapon which is being used by the accused has been taken and borrowed by the police officer. So court in the Pulkari Kataya versus Emperor case has stated that only the statement, the latter part of the statement is relevant, that is, which has given the help in discoveries of the thing, not entire statement. Clear?
Yes, sir.
So next further, and section 2032 has been incorporated under section 26. that relates to the dying declaration and many more things. And later again, there is some changes in the part third also, confession, which has been explained relating to section 28 and 29 of the Indian Evidence Act, which has now been incorporated in the section 22. And there is a one basic section and which must you have to understand is dying declaration. So can anyone tell me what is the dying declaration? It is now being incorporated in the section 26. Where any person has made a statement as to the cause of his death or the circumstances which leads to cause his death, if the death of the person is in question, the statement made by such person is relevant. This is known as a dying declaration. Dying declaration may be made is of two kinds as to the cause of his death or the circumstances which leads to the death. So I'm not here to teach you the entire sections, but I'm giving you the brief about the section. Okay, now the most important section in this regard is section 45 of Indian Evidence Act. Now it is 39, section 39 of the Bharati Sakshi Adhiniyam, which talks about the opinion of an expert. So this is being mentioned in the section 39. And also the character is relevant. What about the relevancy of the character? Character, relevancy of the character. Now, if I'm asking you the question relating to the character, whether the character of an accused person or the defendant is relevant in the subsequent suit. So under the Bharati Sakshi Adhiniyam, under section 46, it has been incorporated. Section 46, 47, 48, 49, and 50. So if we talk about the civil nature character and criminal proceeding, the character in the civil proceeding is not relevant. And in the criminal proceeding, there may be the good character or the bad character. The good character is relevant, but the bad character of an accused is not relevant in the subsequent suit, because no person can be condemned, no person can be convicted merely only on the basis that he was an accused, he was a convicted, he had a bad character. No, this is not the principle of the Indian Evidence Act or the Bharati Sakshi Adhiniyam. Is it clear? So, and under the section 41, there are many sections which are also being incorporated. These are section 47A, 41, clause 2, etc. So, what are the certain changes being made under the part third of the Bharatiya Sakshi Adhiniyam? There are some laws relating to the Bharatiya Sakshi Adhiniyam under the part third. Firstly, it is stated under section 51 that no fact of which the court will take the judicial notice need to be proved. It was being given under section 56 of the Indian Evidence Act. So now it has been incorporated under section 51, and section 52 incorporates clause B, C, D, E, which has been reformulated as per the present scenarios. There are some certain changes have been made. And what about section 57 of this adhiniyam, which talks about the primary evidence? And four new explanation, that is explanation number 4 to 7, have been added under the Bharatiya Sakshi Adhiniyam. That relates to the electronic or digital record. Now, the very basic principle of this digital record is given under section 61 digital record. It is introduced. This is the only section which has been introduced under section 61 of the Bharatiya Sakshya Adhiniyam, which states that nothing in this adhiniyam shall apply to deny the admissibility of the electronic or the digital record in the evidence on the ground that it is an electronic or the digital record. And such record shall, subject to section 63, shall have the same legal effect and the validity and enforceability as other document, which was section 65 of the Indian Evidence Act. Now, this is the basic section which has been given under section. This is the basic principle relating to the digital record or electronic record has been mentioned in the section 61. This is the new principle. It has not been given under any of the section of the Indian Evidence Act. Now, I would tell you the one more things relating to the digital record. In case of the digital record, there are a leading case, and there are some leading case of the Honorable Supreme Court, in which, in number of the cases, the Supreme Court has stated that the digital record or electronic record must be given by the person who had an original digital record. It means if I am using this laptop and court required this laptop during any So I hope you are clear with this point. So in the next lecture, we will cover many more things relating to the Bharatiya Sakshya Adhiniyam and what changes has been made under the Bharatiya Sakshya Adhiniyam, which was not incorporated under the Indian Evidence Act 1872. Thank you so much and have a nice day.